begin just so I have a sense of who the audience is, since this covers two very distinct fields, Islamic law and American criminal procedure. Just curious, especially since we have such a small audience, are these are you Islamic studies people? All
no? No, I just have an interest in it through anthropology.
Anthropology, okay. So Islamic studies, okay. I often have to find myself, particularly in the Q&A, translating one side for the other, Islamic law for the laws school people and American law for the Islamic studies people, understandably. All right, well, thanks for coming. It's nice to be back here at BU, where I spent a lovely semester a year ago. The topic of my talk, Due Process in Islamic Criminal Law, is a long-term research project in Islamic criminal law, and today I will present the central claim that animates that research. And it is this: so-called Islamic criminal law cannot be practiced, indeed is not properly practiced, without being accompanied by and regulated by rules of criminal procedure that also derive from Islam and that correspond with the substance and the theory of Islamic crimes and punishments. Now, the long-term goal of the project is to identify and articulate a body of such rules and to propose a doctrinal framework for them within Islam. In today's talk, I will just present the conceptual premises of the project as well as some illustrations and observations. Some definitions first. By rules of criminal procedure, I mean rules that govern how crime can be investigated and prosecuted, or how it should be investigated and prosecuted, what limitations bind the state, what rights accrue to suspects and defendants in the process, rules such as those we now find in our 4th, 5th, 6th, 8th Amendments to the Constitution, and that are replicated in constitutions around the world, as well as in international instruments such as the International Covenant on Civil and Political Rights and other such instruments. Freedom from arbitrary arrest or detention, the right to notice and an opportunity to be heard on criminal charges, the right to counsel, a privilege against compulsory self-incrimination, that body of rights and protections that we generally consider to be criminal due process rights. Now, rules like this were not systematically articulated in Islamic jurisprudence, and they have not been systematically articulated in modern times. I meant to say were not systematically articulated in the classical jurisprudence, and they have not been systematically addressed in modern times from an Islamic framework, at least not from the perspective of what Islam itself requires or forbids in these matters. So that's the definition of criminal due process. As for the definition of Islamic law, for these purposes, I mean two things. First, the rules and principles of the Quran and Sunnah themselves. These are Islam's sacred texts and the primary sources of law in Islam. The Quran as the word of God to Muslims, and the Sunnah or traditions as the collection of statements or actions by the Prophet Muhammad, and of a lesser degree of authority, statements and actions of his companions. And second, rules and principles Muslim jurists have derived from these texts over the 1400 years of Islam. The fiqh, jurisprudence or positive law that has been compiled in hundreds of volumes over the centuries, is still being articulated today, both as a scholarly matter and as an actual jurisprudential matter in courts, and is still considered the corpus of authoritative articulations of God's law. My argument is that Islamic rules of criminal procedure need to be identified from these sources of law and articulated particularly to regulate the enforcement of Islam's criminal prohibitions and punishments that come from those very sources. Prohibitions on adultery, apostasy, wine drinking, for instance, and the possible punishments of flogging, amputation, death by stoning. Much attention has been given to how these crimes and punishments violate modern human rights norms. My claim is that investigating and prosecuting these crimes under the ostensible authority of Islam, without heeding Islam's accompanying rules of procedure, violates Islamic norms and thus constitutes injustice from an Islamic perspective. And in part, this is because Islam's criminal prohibitions and punishments are not, I hope to illustrate, adequately or properly addressed by procedural rules and standards of non-Islamic origin. Now, one final caveat. Let me emphasize that my focus here is not on identifying what evidence there is in Islam of rules and principles of modern Western criminal procedure, or whether there is authority or precedent in Islamic law for meeting international standards of criminal due process. Some others have recently looked at that, and I myself started out that way, seeing what Islam had to say about modern notions of due process that originated from outside the Muslim tradition. And there's certainly merit in doing that. Identifying Islamic authority for modern notions of due process can certainly increase compliance with those protections, or at least the incentives, political and otherwise, to comply with them. But the focus here is on identifying Islam's own rules and principles of criminal procedure, whether or not they meet or even look like Western or international rules and standards, indeed particularly when they don't, given the very different crimes and punishments to which they apply or should apply today. So I will present this premise in more detail, then share a few illustrative findings, then offer a few observations, conclusions, and then I look forward to your questions and comments. Laws implementing so-called Islamic criminal law have been enacted in several Muslim-majority countries over the past 35 years. Libya started it in 1972, the United Arab Emirates 78, Pakistan in 1979, Iran in 1982, the Sudan in 83, the states of northern Nigeria in 2002. Such laws have also been passed but not yet enacted, or were passed but were not yet enacted elsewhere in two Muslim-controlled states of Malaysia, for instance, 1993, 2002. Islamic criminal law is also applied by the Islamic courts that have arisen to govern much of Somalia over the past 10, 15 years. It's also being applied, we're told, in new local courts in Afghanistan. And we're hearing about its possible enactment elsewhere, for instance, the province of Indonesia. Now, it has always been applied in Saudi Arabia, Qatar, Yemen, the states of the Arabian Peninsula, which were more or less unaffected by the wave of codification along Western lines that swept through the Muslim world in the 19th, 20th centuries. And Islamic criminal law can also be applied in countries where the law authorizes its ad hoc application. One example of that is Afghanistan, where the Quranic crime of apostasy is not listed in the criminal code, but a threatened prosecution for that crime in 2006, which you might recall, got a lot of attention, was arguably lawful under a constitutional provision, a provision of the Afghan constitution that authorizes following Islamic law in matters not addressed by the constitution or other laws. Another example of ad hoc application, by the way, is the nation of the Maldives, which in 2007 drafted a new penal code along Islamic lines, specific Islamic crimes and punishments, aided by a similar catch-all provision in its penal code that allowed that legislation, and by the way, aided also with the assistance of an American law professor, Paul Robinson from the University of Pennsylvania, who is our expert, the U.S. expert on codification of substantive criminal law. He was hired by the Maldives to help them write their Islamic criminal code, but not a criminal procedure code, a substantive criminal code, what acts constituted crimes and what punishments followed. And on the substantive scope of Islamic criminal law, what conduct is considered criminal and what punishments follow, this body of law or doctrine is relatively well established in Islamic jurisprudence on the basis of the Quran and the Sunnah. Classical Muslim legal scholars identified what amount to three distinct categories of crime. The first is the Quranic crimes, the hudud, which call for the harsh physical punishments for which Islamic criminal law is best known. Crimes are perhaps familiar to you all: theft, brigandage, adultery, false accusation of adultery, wine drinking, apostasy. Some people put rebellion in there, and some contest whether wine drinking and apostasy should even be in there. The punishments for these crimes: flogging, amputation, death by crucifixion or stoning. That's one category of crimes, and it's a relatively small one. The second category of crimes articulated from the Quran and in Islamic legal theory is that of bodily injury offenses, jinayat, which call for just retribution, qisas, or diya, which has gotten suddenly a lot of popular attention, the topic of diya after the accidental shooting of the Iraqi soccer goalie, and then there's a story from 2 days ago about a 100 camel payment for the death of, for the murder of someone in Somalia, so suddenly diya is in the news. Diya and qisas fall under the second category of crimes, which is a quasi-tort, quasi-criminal category, where victims sue, essentially, the wrongdoer for just retribution or accept compensation in return. There's a third category of crimes, which is all other crimes, meaning the vast majority of possible crimes, which are unspecified, uncodified, and call for corrective punishment, ta'zir, in the ruler's discretion. That category, by the way, also includes crimes in the first two categories that are not sufficiently proven, and so they default to the ta'zir category. Now, in today's practice of criminal law, one or another version of these categories, particularly the hudud category, provides the substantive framework for the practice in these countries. The Quran and Sunnah also indicate rules of evidence about the number and quality of witnesses required to prove these crimes, again, particularly with respect to the hudud offenses. Classical scholars developed a body of jurisprudence on the basis of this on this topic as well, and those rules too, the rules of evidence, apply to varying degrees in the modern practice of Islamic criminal law. But a system of criminal procedure, rules that govern how suspects can be investigated, how they can be prosecuted, and what limitations bind the state, what rights accrue to suspects and defendants, has never been articulated in Islamic legal theory. The Quran and Sunnah say very little on the subject, and pre-modern jurists developed no comprehensive theory or framework of criminal procedure, and certainly nothing like the categories of substantive crime that I just mentioned. Historical research, meanwhile, indicates that in the pre-modern Muslim states, at least in the Arab Ottoman world, matters of criminal procedure were governed and practiced mostly by executive authorities, sultans, governors, local rulers, police officials, and the rules they promulgated, rather than by Islam's scholar jurists and the religious doctrines that they promulgated. All indications are that these rules and practices by executive authorities hewed heavily in favor of state power, with few protections for criminal suspects and defendants, and little or no reference to rules or principles of Islamic legal theory or Islam more broadly. So there is no comprehensive or uniform body of rules of procedure in Islamic jurisprudence to govern the modern state practice of Islamic criminal law. Now, it's no aberration in world history that pre-modern Muslim jurists did not provide a template for criminal procedure, or that state powers of criminal law enforcement were relatively unconstrained in the pre-modern period. Rules for the criminal process, and certainly limitations on state power and protections for suspects and defendants, are a relatively recent phenomenon in the West itself. It wasn't until the late 18th century that continental Europe fully abolished torture from its criminal procedure, that England settled on its beyond a reasonable doubt standard for proof in a criminal trial, and that we ourselves promulgated our Bill of Rights, and France followed afterward with the Declaration of the Rights of Man. So it's a relatively modern phenomenon that rights of suspects and defendants are existing in the constitutions and codes of the world. And as we know, that when the Muslim world modernized, so to speak, its laws, it simply largely adopted codes and constitutions from the Western world. So it is not a surprise that Muslim jurists never developed such a body of rules. But still, one might ask, why have such a body of rules? Why do we need an Islamic code of criminal procedure if the Quran and the Sunnah didn't say much about it, if the Prophet and the companions apparently fared well without one, and if the modern states are doing fine, so to speak, without a code of criminal procedure? Indeed, we might go further. Not only have the states of the Muslim world adopted the constitutions and codes of the constitutions and codes of Western countries to govern their criminal procedure, but they have even asserted that some of the rules in them are grounded in Islamic law and consistent with, if not only consistent with, Islamic law. Moreover, these states of the Muslim world have joined international treaties that mandate the protections of modern criminal due process, and they have joined other Muslim-majority countries in adopting their own declarations of human rights. The 1981 Universal Islamic Declaration of Human Rights, the 1990 Cairo Declaration on Human Rights in Islam, the 1994 Arab Charter on Human Rights. All of these declarations include the litany of modern rules of criminal due process. All of them assert that the rules are grounded in Islam, indeed, if not required by it. Well, my answer as to why we need to articulate an Islamic code of criminal procedure, I have two answers. Pardon me. That's out of place. One is that rules drawn from Islamic law and based on Islamic principles, rules of Western origin, of non-Islamic origin, are always vulnerable to attack or dismissal as inauthentic or illegitimate or simply irrelevant to the modern practice of Islamic criminal law. Their enforcement and perhaps even their continued existence in these countries is far from secure in the current wave of Islamization and any future one. Second, although there's no system of criminal procedure in the Quran and Sunnah and the jurisprudence, values and principles, and in some cases actual rules that should apply in criminal procedure as they apply anywhere else, do appear. And the failure to recognize and enforce these rules is thus a failure, I argue, to honor Islamic notions of justice, even as states claim to practice Islamic Criminal Law. I'll provide two illustrations in a moment. First, let me note that the point is even stronger with respect to the jurisprudence than it is with the Quran and the Sunnah. Although classical Muslim scholars didn't articulate a full system of criminal procedure, they did specify some rules for the process, and they repeatedly invoked the authority of the Quran and the Sunnah in doing so. And not surprisingly, many of these rules and principles, both those in the sacred texts and those in the jurisprudence, provide or suggest nothing other than protections for individuals, suspects and defendants, limitations on state powers of investigation and prosecution. But few of these seem to be honored or even recognized in the modern state practice of Islamic criminal law. Let me give two examples. One of them stems from research I've already conducted into rules of search and seizure in classical Islamic legal theory, what would be considered to fall under our Fourth Amendment to the U.S. Constitution. In states that practice Islamic criminal law today, the religious police are among the most prominent investigators and enforcers of that law. These state officials have various duties and various names, Mutawa'in in Saudi Arabia, Hizbah in Pakistan. But in each case, central to their mandate is the detection and prevention of Islamic crimes, such as drinking alcohol and engaging in illicit sexual relations. In performing this function, these officials are apparently the most regular abusers of modern, Western-based rules and principles of criminal investigative procedure. Reports issue regularly of their intrusive home entries, warrantless searches and seizures, extended interrogations and beatings of citizens. But also, as a result, these officials are flagrant violators of a bedrock rule of criminal procedure in Islamic jurisprudence as well. And that is that the everyday enforcers of religious criminal prohibitions, particularly those against drinking and illicit sexual relations, must exercise prudence and restraint in the performance of their duties. Let me explain. This duty that modern-day religious police purport to perform, Hizbah, here supervision, the duty originates in the Quran in several verses that enjoin Muslims to command right and forbid wrong in their daily lives. Rules and guidelines for the person who does this, who performs this duty, the muhtasib, appear very much in classical legal literature and are much discussed in that literature. Two well-known discussions appear in works by Al-Ghazali, his Ihya Ulum-ad-Din, and Al-Mawardi, Al-Ahkam al-Sultaniyya. In this literature, Al-Ghazali, Revival of the Religious Sciences, and Al-Mawardi's Ordinances of Government. In this literature, those two and other works, the jurists consistently set limits on the muhtasib's powers, and the starting point of these limits is that the muhtasib may not act on wrongdoing that is not manifest, dhahir, and may not expose or even seek to expose wrongdoing that is not committed publicly. Now, the rule has corollaries as well as exceptions. One corollary is that the muhtasib may not seize or search suspected wrongdoers without a specified quantum of individualized suspicion, a particular sign of guilt, alama khassa in Al-Ghazali's formulation. One exception, meanwhile, is that the muhtasib may enter a home if, and this one is Al-Mawardi's version, there is, quote, indicative evidence, amarat dallat, that a serious crime, such as adultery or homicide, is underway. But beneath this threshold, i.e. a specified quantum of suspicion, the message is clear. However it's articulated by different jurists, muhtasibs are generally forbidden to intervene in the private lives of fellow Muslims, even to enforce the religious prohibitions that are central to their duties. Now, it's clear that modern-day Muslim religious police do not generally abide by this rule in enforcing Islamic criminal law, and that the rule is firmly grounded in the Quran and Sunnah makes this apparent disregard for it, and let's repeat, in regimes that have formally implemented Islamic crimes and punishments, all the more troublesome. Spy not on each other, says the Quran, 49:12. Enter not houses other than your own until you have asked permission and saluted those in them, 24:27. These commands, along with several similar injunctions in the Sunnah, are the express authority for limiting the powers of the muhtasib in the ways that Al-Ghazali and Al-Mawardi and many others spell out. Now, what's the purpose of these commands? Perhaps they suggest that privacy is a key counterweight to enforcing Islamic criminal prohibitions. Perhaps they indicate a divine disinclination to prosecute and punish individuals for conduct that might be considered more immoral than criminal. I consider these possibilities and others in my forthcoming article on this topic. But whatever the rationale, it is certainly not vindicated when a state enforces Islamic criminal law without heed for the duty of restraint these commands suggest. And by the way, whatever goals might underlie those commands, they are not protected by search and seizure constraints of modern, Western origin. Our Fourth Amendment and its analogs in other constitutions and treaties certainly set out rules for when homes may be entered and how people may be investigated, but discouraging investigators from prying into the lives of individuals is not among those rules, particularly when there is reliable evidence of wrongdoing. Now, my second example echoes the first one, but cuts more broadly into the theory and practice of Islamic criminal law. The Quran and Sunnah reflect, quite simply, considerable reluctance about enforcing the criminal prohibitions and punishments that these very same sacred texts set out. The Quran encourages forgiveness of one sort or another upon repentance for several of the hudud crimes. Meanwhile, one of the best-known statements of the Prophet is the admonition, repel the hudud. And several traditions recount episodes in which Muhammad discouraged Muslims from bringing wrongdoers to his attention, labored to avoid adjudicating their guilt, or forgave them outright. Meanwhile, the strict evidentiary rules of the Quran and the Sunnah seem at times intended precisely to avoid conviction and infliction of the specified criminal penalties. For that reason, for instance, one modern Muslim scholar, Salim Alawa from Egypt, asserts that because of the rule that adultery, absent a confession, can be proven only by the testimony of 4 adult males to the actual act of penetration, no case of adultery has ever been properly proven in all of Islamic history. Now, what rule or principle of criminal due process can be deduced from these precedents? It appears to be a principle of discouraging the prosecution and punishment of wrongdoers. I like to call it a presumption of non-prosecution, or at least a preference for non-prosecution. Now, this preference, discouraging the prosecution of wrongdoers, is certainly not a principle of criminal due process in modern Western or outside Islamic norms, but it is unmistakable in Islamic legal theory. So if a state does not honor this preference in its practice of Islamic criminal law, if it doesn't even recognize that preference, can it really be said to be practicing Islamic criminal law? So in short, although there's no system established of criminal procedure in Islamic legal theory, there are certainly rules and principles that bear on its implementation and that were articulated alongside the crimes and punishments in the doctrine. And so the failure of modern states to recognize these rules constitutes, in my position, is both a significant theoretical inconsistency in the practice of Islamic criminal law and, worse, more importantly, resulting in injustice from an Islamic perspective, as the above illustrations, I hope, show. And that is the case even if the standards of Western-inspired criminal procedure are being met. Now, I'm not saying that none of these principles are recognized in this contemporary practice. As just one example, in one of the 2 highly publicized adultery cases from Nigeria in recent years, this one, the Safiya Hussein case, Nigeria's Sharia Court of Appeal invoked the Islamic privacy principle, one of the principles I just talked about, as one of several grounds for reversing her conviction of adultery. The defendant in this case, Ms. Hussein, was an unmarried woman who had gotten pregnant. On that ground, neighbors brought her to the court for prosecution for adultery. She was convicted, sentenced to death by stoning. The High Court reversed on several grounds, legal grounds. One of them was the principle that her neighbors had pried into her life in bringing her to court, and then to bring her to court, so her case never should have been prosecuted in the first place. And the court cited the hadith, the relevant hadith, as well as the Quranic verse, spy not, 49:12, in reaching this result. Even against, by the way, the opposing texts and hadiths that the prosecutor held up to justify the prosecution and punishment. And in discussing this case, by the way, I'm indebted to Ruud Peters, who reports on it in his chapter in the wonderful 2006 book, Dispensing Justice in Islam. So there clearly is a place for Islamic rules of criminal procedure in the practice of Islamic criminal law, perhaps even a readiness for them. For a doctrinal framework for these rules, I suggest looking at the 5 basic interests or principles, the quintet of interests that classical jurists identified as the goals of Islamic law, ad-dururiyat al-khamsa: the protection of religion, life, intellect, reputation, property. Reputation is sometimes called honor and sometimes called lineage, but basically we have a quintet there: religion, life, intellect, reputation, property. Now, you might notice these sound a little bit like the values protected by the Due Process Clause of the United States Constitution: life, liberty, and property. Care must, of course, be taken not to stretch or apply the Islamic concepts or any of their sub-concepts in such a way as to make them foreign to their context and meanings, but surely these principles, or some other formulation of the goals of Islamic law, maqasid al-sharia, suggest at least the starting point of a doctrinal framework in Islamic law for the articulation of Islamic rules of criminal procedure. And there are plenty of places to look for those rules. I've already mentioned the Quran and Sunnah, the jurisprudential treatises and commentaries, positive law manuals, al-Hidayah, al-Mughni, Bidayat al-Mujtahid, the collections of legal rules by classical jurists, fatwa collections, histories of judicial practice, Adab al-Qadi, Muhtasib manuals, I've already looked at most of those, and other such legal material from the classical period, as well as statutes and court decisions from the modern period, such as the Nigeria decision I just talked about, in countries in which Islamic criminal law is practiced today. All of these sources are rich material in which one can find rules and principles of criminal procedure. Now, there's a lot more I could say about this, but I would like to turn to your comments and questions. In closing, let me note the overlap, if I may suggest, in my claim, between the interests of so-called Islamists, on the one hand, those who wish to make Muslim societies more Islamic, and so-called liberal reformers, on the other hand, those who wish the Muslim world to be more like the West and to comply with international standards of criminal justice, and who might be happier if there was less Islam in the law of the countries of the Muslim world. If there are Islamic rules and principles of criminal justice that are not being followed, and that would bring greater limitations on state power and protections to criminal defendants and suspects, and I submit to you that they are, both of these groups, the Islamists and the liberal reformers, should welcome the systematic articulation and enforcement of these rules. Now, this is not to say that all of the rules that are in the classical and modern sources will comply with international standards. Indeed, one area where they do not, that I've also written about, is investigative torture. It's clear that some classical jurists permit that practice, while others deem it forbidden. But the fact that some Islamic rules of criminal procedure might fall short of contemporary standards does not seem to me a good reason to avoid identifying them. And I admit I'm happy to report that so far most of the rules I'm able to find meet or exceed the contemporary standards. The above examples I've given, and we can talk about others. There's a quasi-habeas corpus remedy. There's certainly a standard of proof beyond a reasonable doubt. Strict rules of confessions, how they can be obtained and not always followed under the investigative torture line of reasoning, but how they can be presented and obtained, and several others. So with that, then, I will stop, and thank you for listening, and I appreciate your comments and questions.